Once again, I'd like to welcome everyone to our webinar, Navigating Research in Pediatric Populations. We at Quorum are excited to be sharing this topic with you today. I'm Ari Burgess, Quorum's Director of Client Relations. This is the second of two webinars on this particular topic, and this is the third series of webinars we've conducted in this year. On that note, if you'd like to stay informed on Quorum initiatives, such as our webinars, please do be sure to sign up on our mailing list. You can find the list by going to our website, www.quorumreview.com, and then clicking on News and Events. Once you've clicked on News and Events, you'll find in the upper right-hand corner there is a little box for signing up for the mail list. This is how you would join our mail list. By doing so, this will ensure that you'll receive the latest e-news updates from Quorum, including Quorum's responses to FDA guidance, trends in clinical trial review, and our quarterly e-news publication, the Quorum Forum. Immediately following this webinar, we invite you to participate in a brief survey that will help us know what types of topics interest you. This does help us to continue to offer webinars that are current and informative. So at the end of the webinar, please do take a few moments and complete the survey. I'm going to be giving you a brief overview of Quorum before introducing our presenter, but first off, I'd like to cover a few housekeeping items. First of all, questions and answers. Feel free to submit questions at any point during the webinar using the chat box on your webinar dashboard. Responses to your questions will be sent by our presenters within a few days following the webinar. And finally, the recording and the slide deck. The webinar slide deck and the recording of today's session will be posted on our website within 5 business days. We'll email you a link to view the recording as soon as it's available, and do go ahead and feel free to share this link with your staff and or your colleagues. I'd like to take a few moments before we get started to talk a little bit about Quorum. Quorum is fully accredited with the Association for Accreditation of Human Research Protection Programs, or AHRP, through 2014. Quorum is compliant with both FDA and OHRP requirements. Quorum has boards that are appropriately comprised to review studies in both the United States and Canada, and currently Quorum is one of the largest central IRBs with approximately 200 employees, and of those IRBs that are of equivalent size, we are the only IRB that is privately held. Quorum's proud of our number of employees that hold CIP certifications, which is Certified IRB Professionals. Currently, 60% of our affiliated IRB members, 40% of our regulatory staff, and 20% of our study manager and support positions hold the CIP certification. Quorum's turnaround times are among the best in the industry. Quorum holds 13 convened board meetings each week, in addition to having our expedited review staff. This allows us to offer 24-hour turnaround of site documents from the receipt of a completed submission to posting the approval documents on the portal, a 36-hour review cycle for amendments, and same-day site changes. To streamline the site submission process, Quorum offers one-time CV and audit documentation submission. And then among Quorum's founding principles was the customer experience. So to support that experience today, we have our staff available from 8 a.m. to 8 p.m. Eastern Time. And each study with Quorum, regardless of the size, will receive its own study manager assigned to that study. Additionally, Quorum offers a secure web portal where you can find all of your approval documents. You'll also find different status reports and our smart form site information questionnaire. And Quorum's aware that there are special needs for phase 1 and post-marketing studies. We have special teams and processes for these kinds of studies. We work with hospitals and institutions, and we're able to support their unique needs by having flexible, customized processes. And finally, we're aware that quality is supremely important for our customers, so we perform a 100% quality check on all documents. And now I'd like to introduce today's expert presenter, Mitchell Parrish. Mitchell joined Quorum Review IRB in January 2010 as an attorney in Quorum's regulatory department. Prior to Quorum, Mr. Parrish worked as a regulatory counsel for Western IRB and as a regulatory advisor to the National Cancer Institute's Pediatric and Adult Central IRBs. Mr. Parrish earned his Juris Doctor from the University of Oregon Law School and is a member of the Washington State Bar, including the Health and Corporate Law sections. Additionally, Mr. Parrish is a member of the American Bar Association and is a Certified Institutional Review Board professional. And now I'm going to hand the presentation over to Mitchell.
Thank you for that introduction, Ari. For all of those listening in today, good morning, and to those of you on the East Coast, good afternoon. My name is Mitchell Parrish, and today I'll be talking about navigating research in pediatric populations. Now, for the next 60 minutes, we're going to be discussing this topic and how I've broken down this topic is into 7 different sections. First, we'll start off discussing the importance of research in pediatric populations. Then we'll move into the regulatory landscape, or in other words, what are the actual regulations that apply to research in pediatric populations, and what are the regulations that apply when you'd be submitting research involving pediatric populations to the IRB. Next, we'll move into the bulk of our presentation. First, I'll start off by talking about research that's actually permitted in pediatric populations per the regulations. Then we'll move into recruiting pediatric populations, consenting pediatric populations, and finally, conducting research in pediatric populations. I'll conclude all of that with the key takeaways or the things that I hope you have learned from listening to this presentation today. So with that, let's get into our first section. Importance of research in pediatric populations. Now, I like to put this up front in the presentation because if we don't know why it's important to conduct research in pediatric populations, or if there were no research being conducted in these populations, we wouldn't even have to discuss the next series of topics today. So a lot of people say the evolving view of children in research has changed from protecting children from research to protecting children through research. Let's take a look at those 2 views. So the old view, protect children from research. Here, the view was if you're going to enroll a child in research, they're going to be subjected to potential harms, unknown adverse events, and things of that nature. So we need to protect children by not subjecting them to these potential harms. Well, the end result of that view, however, is a limited number of medical products evaluated for use in children. So when this occurs, when there's actually a limited number of products for use in children, then children don't have available therapies that some adults would have. And also, if you're using therapies that are made for adults and trying to adapt them in children, this can result in various harms. For example, a dose that's ineffective or a dose that would be too high and therefore harmful. So as a result of these thoughts, we have the new view. We can protect children through research. So the result here is children are subjected to potential harm by being in the research. However, such harm can be mitigated by ensuring ethically and scientifically sound research that includes additional protections for this vulnerable population. Now, the end result of this new view is the development of medical products appropriately evaluated for use in children. So the end result is with more products evaluated for use in children, children are actually better protected because then you have products specifically evaluated for children, so you can have the dosing more accurate and also have more therapies available to the pediatric population. In terms of providing more support for this new view of research in pediatric populations, without medical products approved for children, certain harms may occur. Now, I already briefly touched on these, but again, you have the denial of a potential treatment. So some physicians may refuse to use a drug or a device that's approved for adults in children because they don't want to use that product off-label. The next potential harm is the wrong dose. So you could have a dose that is too high and therefore extremely harmful. An example of this is something that happened in the 1950s. The antibiotic chloramphenicol was widely used in adults at that time to treat infections resistant to penicillin. But many newborn babies died after receiving this drug because doctors thought the drug would actually work in the children, but what ended up happening is the immature livers of these children could not actually break down the antibiotic. You also can have a dose that's too low. And if you have a dose that's too low, that's ineffective, and therefore the product is doing no good in a child. Additionally, children are not simply small adults. You cannot just adjust the dose of a drug or modify a product based on a child's weight. A child does not simply weigh less than an adult. Instead, there are many different considerations when you're thinking about a child versus an adult. One, you have the dynamics of growth. You have the maturation of organs, changes in metabolism throughout infancy and childhood. There's changes in body proportion, and also other developmental changes that affect how drugs are metabolized. So simply adjusting a dose in an adult and then down into a child who weighs less is not always effective for a variety of reasons. And finally, drugs may also behave in a qualitatively different manner based on age. There also may be quantitative differences, including dose-response relationships, pharmacokinetic parameters, magnitude of effect, risk of adverse event, and other variables that are required defining based on the study population. So what this means is basing conclusions on the effects observed in adults is not always useful or feasible because responses in pediatric patients may be different from those reported in adults. So to recap, again, it's important to conduct research in pediatric populations because without this research, there may be potential harms to children by, again, denying a potential treatment or having the wrong dose. Also, you need to have research in pediatric populations because children are not simply small adults. There are a lot of factors to consider, and also products themselves behave qualitatively and quantitatively different based on age. So the key with that is medicinal products should be studied in children who are representative of the range of patients likely to receive the product once it's marketed. In terms of a few examples of success in conducting research in pediatric populations, and specifically success in changing the labels of products approved for adults, but now evaluated for use in children, so there's going to be new dosing information or new administration information. One example is ibuprofen. I think everyone's very familiar with this drug. And here, studies in infants established safe and effective dosing information for children ages 6 months to 2 years. So ibuprofen has always been used to control fevers in infants, but after research in infants, parents and doctors could be more comfortable in actually what the dosing should be for this young population. Another drug is Xanax. Here, studies in infants established accurate dosing information for safer and more effective use of the drug to manage gastroesophageal reflux in seriously ill infants. Another commonly used drug is Claritin. This treats allergies and hives in children, and studies established that patients ages 2 to 5 require a lower dose compared to older children and adolescents. So there was definitely misdosing before this study was done because people were not taking into account the different ages and how a body may respond. There's Pepcid tablets, capsules, and oral solution, and here studies revealed that patients up to 3 months require a lower dose to treat reflux disease because their ability to get rid of the drug is less than that of children and adults, so something very important to know in reducing the risk of an adverse event to a child taking Pepcid. And finally, midazolam. This is used as a sedative, and a lot of key information came from studies in this product. So studies actually showed a higher risk of serious and life-threatening adverse events for children with congenital heart disease and pulmonary hypertension, and identified the need to begin therapy with doses at the lower end of the dosing range to prevent respiratory problems. So this research really showed some significant issues with the administration of this product, and so by knowing the problems with this product and knowing how to actually dose with this product in children, children are better off because they still have this product available for use, but it can be used more effectively and also used in a manner that will not cause adverse events. Now, I just talked about why it's important to conduct research in pediatric populations. What I'm not saying is that means now we should just have all children be in research studies to make sure there's all these products available for children. Again, there's going to be specific instances where we want to conduct research in pediatric populations, and those instances are going to be very important to take on. But also we have to keep in mind, we have to balance the development of new products with still protecting children. So when children are enrolled in research, we really have to consider and make sure that research is ethically and scientifically sound. And we also have to make sure risks to children are mitigated that are in research. And the people responsible for mitigating these risks are all parties. I'm talking sponsors, CROs, investigators, research staff, the IRB, and the federal government. Everyone needs to work together to ensure the research is ethically and scientifically sound to make sure that new products are developed, but also that the children are protected. So that's why it's important to actually conduct research in pediatric populations. So if we want to go about conducting this research, what are the regulations that apply when we're talking about this type of research? And we're talking about submitting a research study in the pediatric population to the IRB. So in the United States, the two most prevalent agencies when we're talking about developing new products are the FDA and DHHS. So when I'm talking about the FDA today, I'm going to be referencing the regulation 21 CFR 50, specifically subpart D. This is the additional safeguards for children in clinical investigations. Also under the FDA, we have 21 CFR 56. That's the regulation that applies to institutional review boards. I also note acts down below 21 CFR 56. We have the FDA Safety and Innovation Act, the FDA Amendments Act of 2007 with new pediatric tracking requirements, and the Pediatric Research Equity Act. I included these because this is really for your own interest. Again, the FDA has made a push to have children protected in research, but also to encourage researchers to actually conduct research in children, so we have those products evaluated for minors. So this is interesting legislation that I have there if anyone's curious. In terms of the Department of Health and Human Services, or DHHS, we have the regulation 45 CFR 46. Again, this is the regulation I'm going to be referencing a lot throughout this presentation, and specifically Subpart D, additional protections for children involved as subjects in research. One thing to note, the FDA and DHHS regulations, the two top ones there, the top of the screen, are extremely similar. In fact, a lot of the time when we're going to be going through the slides today, the language that both regulations use is identical. Next, in Canada, for those of you conducting research in Canada, there is specific documentation out there about conducting research in pediatric populations. Even if you're not conducting research in Canada, there are some helpful documents there when you really want to consider the various factors when you're going to be conducting research in children. One document is the Tri-Council Policy Statement, or the TCPS-2. It's the TCPS-2 because we are actually on the second version of this document. This is a very pivotal document in Canada, and it's akin to that 45 CFR 46 regulation that I just talked about from the Department of Health and Human Services. So it's sort of an overarching human subject protection document. Then specifically related to children, you have the ICH E11 document, Clinical Investigation of Medicinal Products in the Pediatric Population. Here, Canada actually gets into very specific instances of conducting research in pediatric populations. And Health Canada took it a step further and added to this document an addendum to further explain issues related to research in children. So those are the regulations, guidance documents, and acts that we should consider when we're talking about research in pediatric populations. That's not all-inclusive, but again, I really wanted to point out the main regulations that we'll be considering today. So now let's move on to the bulk of the presentation today, and let's start talking about actually conducting research in pediatric populations and how does that work. So first, what research is even permitted in pediatric populations? So IRBs may only approve research in children that falls into one of the following 4 categories. The first category, research not involving greater than minimal risk. Now this seems straightforward enough, but we really need to understand also the definition of minimal risk. So at the bottom of that slide, you'll see the definition, and that is the probability and magnitude of harm or discomfort anticipated in the research are not greater in and of themselves than those ordinarily encountered in daily life or during the performance of routine physical or psychological examinations or tests. So just keep that definition in mind as we talk about the term minimal risk. Now the second category is research involving greater than minimal risk, but presenting a prospect of direct benefit to individual participants. So the IRB may approve research that falls under this category. There are specific things the IRB would have to find in order to approve research under this category. First, that the risk is justified by the anticipated benefit to the participant, and the risk to benefit is at least as favorable to the participant as available alternatives. Additionally, the IRB has to ensure there are provisions in place for the permission of the parent for the child to enroll in the research, their parent or guardian, and there also has to be provisions in place to obtain the assent of the participant. Now this is, for Category 1, this same requirement applies. The IRB would have to ensure that there are provisions in place to obtain the permission of the parent and assent of the child. Now let's move on to the third category. This is research involving greater than minimal risk and no prospect of direct benefit to the individual subject, but likely to yield generalizable knowledge about the subject's disorder or condition. In order for the IRB to approve research under this category, the risk has to represent a minor increase over minimal risk. The study presents experiences that are similar to actual non-research medical, dental, psychological, social, or educational situations. The study is likely to yield generalizable knowledge about the participant's disorder or condition that is vital to the understanding or ameliorating the disorder or condition. And finally, the IRB must ensure there are provisions in place, and this is slightly different than the first two categories. There are provisions in place to obtain the permission of both parents or guardians, so not just one parent or guardian, but both, and also the assent of the child. Another thing to note that's in this category that's not in the first two categories is if the research is going to involve a ward. Now, a ward is a child whose guardian is going to be, for example, the state. So the most common example would be a foster child. If you're going to be enrolling these wards in research, two additional requirements have to be met. One, the research must be related to the child's status as a ward or conducted in a setting where the majority of children are not wards, so schools or hospitals. And two, each ward must have an advocate. This means each ward or foster child, for example, in research must have an advocate that's with them through the duration of the study. And now finally, Category 4. Now this category is much different from the first three. It's different from the first three because if the IRB finds all their criteria met, it cannot still simply approve the research. Other things have to happen. So in order to approve research under Category 4, the following has to occur. Hold on for just a moment as I try to advance the slide. There we go. Okay, so Category 4. Again, Category 4 is sort of a catch-all. It's one where the first three categories don't apply. And because it's a catch-all category, there are these very stringent requirements. So first, the IRB must find and document that the study will further the understanding, prevention, or alleviation of a serious problem affecting children. Here's the big difference between the first two categories and this category. If this research were going to fall under this Category 4, the DHHS Secretary or the FDA Commissioner, depending on whether the research is under the jurisdiction of the DHHS or FDA, the heads of those agencies, in consultation with a panel of experts and following opportunity for public review and comment, must determine the following. The study presents an opportunity to further the understanding, prevention, or alleviation of a serious problem affecting children. The study will occur with sound ethical principles, and that there are adequate provisions for obtaining, again, just like Category 3, both parents' guardians' permission and participant assent. Also, if wards are going to be enrolled in research that would fall under this Category 4, those same requirements would have to be met that I just discussed for Category 3. So those were the four categories. Now that we've heard those four categories in which if children are involved in research, the IRB must find that one of the categories applies, let's test our knowledge about those categories. So here I have a scenario. A survey study is being conducted to record statistics on illicit drug use in middle school and high school students. As part of the research, students are asked to complete a series of questions regarding their drug use, if any, and are asked to sign their name and date the questionnaire. Assuming the study is likely to yield generalizable knowledge about underage drug use and addiction, which regulatory category applies? Is it that Category 1, where it's research not involving greater than minimal risk? That's answer A. Is it option B, that Category 2, research involving greater than minimal risk but presenting a prospect of direct benefit to individual participants? Is it that Category 3, option C, research involving greater than minimal risk and no prospect of direct benefit to individual subject but likely to yield generalizable knowledge about the subject's disorder or condition? Or is it option D, that fourth category, the sort of catch-all category, research not otherwise approvable that presents an opportunity to understand, prevent, or alleviate a serious problem affecting the health or welfare of children? So keep in mind, A is Category 1, B Category 2, C Category 3, D Category 4. We're going to turn it over to you and see what your answers are. So it looks like we have some mixed answers there. It looks like we have a majority of people saying it's A and a majority of people saying it's D. We also have some B and C answers mixed in there. So I'm actually going to go with option number C, and here's why. So the key thing to remember is, while it may seem like this is minimal risk because these children are just filling out a survey study, they're filling out a survey study about illicit drug use. They're also providing their name. If you're providing information that could legally implicate you with law enforcement or something of that nature, the IRB would find that's greater than minimal risk. Also, we know from the question that there would be that potential, the likely to yield generalizable knowledge about that drug addiction or usage in underage. So therefore, it doesn't fall in the catch-all category because there is some actual knowledge that could be gained directly about these children's predicament or condition. So I went with answer C. So that was talking about research that's actually permitted by the regulations, research that the IRB can approve. So let's say your research can be approved. The next step would be you need to know how to recruit pediatric populations and what regulations apply and how that works. So I think we're all aware that recruiting activities into research are the beginning of the informed consent process. Because they're the beginning of the informed consent process, the IRB must review advertisement and recruitment materials. And when I think about the best guidance in terms of what to look for when you're developing an advertisement or recruiting children, I look to the information sheet put out by the FDA called Recruiting Study Subjects. Now this information sheet is not geared directly towards children. It can be children or adults. But no matter, I think it's very important to consider the issues brought up by the FDA in this guidance document about what should be in advertisements and what should not. And I like to think about that specifically from the terms of if an IRB knows the research is directed at a child. So think about it in terms of children involved in the research. So based on this FDA guidance, the IRB needs to review advertising and recruitment to ensure advertisements to children do not do the following. First, the advertisement should not be unduly coercive. Again, this guidance applies to adults and children, but let's think about it from the lens if you're actually enrolling children in your research. Next, you cannot promise or imply a favorable outcome or other benefits beyond what is contained in the protocol. Do not communicate that the study product is safe or effective for the purposes under investigation. Do not make claims that the study product is known to be equivalent or superior to any other study product. Do not include language indicating that regulatory authorities such as the FDA or IRB have approved the research. And do not cause therapeutic misconception. And this is going to be a key issue that the IRB is really going to focus on if you're submitting research to the IRB and advertisements directed at children. So therapeutic misconception, we don't want children to think they're being enrolled or they could enroll in research because that research is intended to help them. Yes, that may be a side effect of participating in some research, but that's not the goal of the research. The goal of the research is to develop a new product. So in an advertisement, don't use the words treatment or medicine. Words like that, they would imply a benefit and really lead to that therapeutic misconception. Instead, think about using other words like experimental drug or things of that nature. Next, do not promise or imply free medical treatment when the intent is only to say subjects will not be charged for participation in the investigation. Do not emphasize payment. Again, this is another key one the IRB is going to focus on. Some IRBs don't even allow, if their advertisement is geared towards children, to even include an amount in the advertisement because money to children is going to have potentially a different effect than it is to an adult. For example, $200 can be a lot of money to a 15-year-old, and that may entice them to be in the research, which may be against their own interest. Next, one thing that you should do is provide information limited to that which subjects need to determine their eligibility and interest. And finally, do not include statements that are generally misleading. Again, the IRB is going to be thinking about how a child may respond to this advertisement, and it's going to be reviewing the language to make sure if you were a child reading the advertisement, it would not be misleading about the research actually involved. So again, understand the FDA information sheet, but really think about it from the lens of a child's view. Now let's test our knowledge in terms of recruiting pediatric populations. A proposed radio advertisement to be played on the local #1 hit music station reads as follows. Do you suffer from asthma? Asthma is a chronic disease of the airways that makes breathing difficult. ABC Health Clinics is conducting a research study to test the safety and effectiveness of an investigational drug that will cure asthma. If you are 16 to 22 years old, have asthma, and want $300 to help buy those next concert tickets, then call 1-800-123-4567 to see if you qualify for the study. I'm going to want everyone to just take a look at that language again. And after you look at that language, here's the question. What information in the advertisement would the IRB find most problematic? Is it A, language that will cure asthma? B, want $300 to help buy those next concert tickets? C, test the safety and effectiveness of an investigational drug? Is it both A and B, or is it all A, B, and C? So the polls are already open. Let's see what you come up with. Okay, looks like we got most people responding, and most people said it was D, A and B. And I would agree with everyone. I would agree. Again, if you're going to say cure asthma, using the word cure really hits on that therapeutic misconception. That's not the intent of the study. It's an investigational drug. Hopefully it will be developed into a drug that can cure asthma, but we don't know that right now, so you cannot say that. Also, $300 to buy concert tickets. In the first place, $300 can be a lot of money to this age group, and you're even tailoring it a step further to this population where concerts may be very appealing. So the IRB is going to take a look at that and find that's unduly influential potentially to include that information and really entice children and people that may be more impressionable into research. So now that we've talked about research that's permitted by the regulations and about recruiting this pediatric populations into the research, let's take it a step further. If you get past those two parts, you have consenting pediatric populations. Now, this section is probably going to be the longest section today. There's definitely a lot to cover in terms of consent and assent when you're talking about pediatric populations. But as we go through this whole section, I want you to keep one major thing in mind. To enroll a child into research, there must be permission and assent. There must be permission of the parent or guardian, and there must be assent of the child. Now first I'm going to start off talking about permission, and then I'll follow that section up by talking about assent. So let's look at some terminology and make sure that's clear in our minds before moving forward. One, we have parent. The federal regulations actually take the time and define this as a child's biological or adoptive parent. Clear enough. We also have the term guardian, an individual who is authorized under applicable state or local law to consent on behalf of a child. Now, one thing that I want to point out, and this is a question we actually get a lot at Quorum that can be confusing to many people, is we also have this term LAR, or legally authorized representative. The definition of an LAR is an individual or judicial or other body authorized under applicable law to consent on behalf of a child. So if you take a moment and just look at that definition, understand that that means a parent is an LAR because they are authorized to consent on behalf of a child, and a guardian is an LAR because they can also consent on behalf of a child. So a parent and guardian can be a subset under LAR. The other thing I want to point out, and this especially applies to that guardian there in the bottom left corner, it's really important to note there's a significant difference between having the authority to consent on behalf of a child for medical care versus enrollment in research. So depending on where you're conducting the research, your local jurisdiction, it's important to know the rights of a guardian. So you may have a guardian and think, okay, they can consent to this child to be in research, but under that applicable local law, they may only be able to consent on behalf of medical care, not to enroll a child in research. So just be aware of that. Now, the definition of permission is the agreement of the parent or guardian to the participation of their child or ward into research. So in other words, a parent must provide their consent to enroll the child into research, and they must provide this consent consistent with the regulations governing consent. So this is just like if you're enrolling an adult in research and you have a consent form that has all the required regulatory elements, you have to have the same thing for that adult to provide their permission, aka consent, on behalf of the child. So that means the consent form should include an explanation of the research, any benefits from the research, how confidentiality of information is going to be protected, contact information, who to contact in case of injury or who to contact in case of questions about the research, if there are any foreseeable risks and discomforts, if there are any alternative procedures that are available, compensation and treatment for injuries if the research is more than minimal risk, and explain that the research that the child will be participating in is completely voluntary, and if the child chooses not to be in the research or if the parent will not consent their child in the research, there will be no loss of benefits. Also, if the child decides to withdraw from the research or the parent wants to withdraw their child from the research, there will also be no loss of benefits. Of course, there are other elements than that that may be applicable depending on the type of research, and those additional elements can be found at 21 CFR 50.25 and 45 CFR 46.116, so keep that in mind. Now, when you know you have the parent or guardian that has to provide their permission, again, aka consent on behalf of the child, how do we know if only one parent or guardian has to provide their consent or if it's both? So we've already actually looked at these categories, those first four categories we talked about, and we're talking about what research the IRB can approve. I'm going to look at those briefly again. So if the research falls into category 1, research not involving greater than minimal risk, here the regulations require only one parent or guardian to consent on behalf of the child. Keep in mind though, an IRB can always decide that even if the regulations only require one parent or guardian signature, that 2 signatures could be required. Next, category 2, research involving greater than minimal risk but presenting the prospect of direct benefit to individual participants. Here the regulations require the permission of only one parent or guardian. Again, keep in mind the IRB can always require their permission of both parents or guardians. We have category 3, research involving greater than minimal risk and no prospect of direct benefit to individual subject but likely to yield generalizable knowledge about the subject's disorder or condition. Here, category 3, different than category 1 and 2, both parents, guardians must provide their permission. That's required under the regulations. Category 4, research not otherwise approvable that presents an opportunity to understand, prevent, or alleviate a serious problem affecting the health or welfare of children. Again, that catch-all category. Here, per the regulations, both parents or guardians must provide their permission. So if the permission of both parents or guardians is required, you should know and be aware how that actually works, because there obviously are going to be some instances where it's not going to be possible to obtain the permission of both parents or guardians. So the regulations say that both parents or guardians must give their permission unless one is deceased, unknown, incompetent, or not reasonably available, or when only one has legal responsibility for the care and custody of the child. So where the regulations require 2 signatures to the permission of both parents, or if the IRB requires the permission of both, know that there may be some instances where that would not have to occur. Now let's test our knowledge in this area. An IRB is reviewing a phase 3 study involving an investigational drug for juvenile diabetes. The drug has some potential significant side effects. Is permission of one or both parents required in this instance? A, 1, since the research does not involve greater than minimal risk. B, 1, since the research involves greater than minimal risk but presents the prospect of direct benefit. 2, since the research involves greater than minimal risk but presents the prospect of direct benefit. 2, since the IRB determined that while the research presents the prospect of direct benefit, the drug has potential significant side effects. We'll turn it over to the audience for your answer. Okay, so our answers are in. Looks like we have the majority of people saying D. We did have a significant number saying C as well. So let's take a look at the answer. The correct answer is answer D. So to go through the answers real quick, A, 1, since the research does not involve greater than minimum risk, we know the study involves greater than minimum risk. That's not correct. B, 1, since the research involves greater than minimum risk but presents the prospect of direct benefit. That could be correct. C, 2, since the research involves greater than minimum risk but presents the prospect of direct benefit. Remember, for that language, it's actually only one signature is required. And D, 2, since the IRB determined that while the research presents the prospect of direct benefit, the drug has potential significant side effects. So under the regulations, under this category, only one would be required. But again, the IRB can always determine that the permission of both is actually required. And here, there were some significant side effects, so even though there was the prospect of direct benefit, the IRB may decide that it's really important that both parents or guardians really think hard and decide about whether or not this is the appropriate study for the child. Now that was talking about permission. Let's move on to assent. Who must actually assent to be in research? So the first term I'm going to start off with is minor. Simply put, this is a person who, under local law, is under the age of majority. So this is under the age of majority or where you would not be considered an adult. You also have the term child. Now, child is actually defined in the federal regulations as a person who has not attained the legal age for consent to treatments or procedures involved in research under local law. So by just looking at that definition, you can see the definition of child is actually also under the definition of minor, because a child would be a minor. Then you have ward. I already talked about what a ward is. Again, a minor who has a guardian appointed by a court or governmental agency. So in other words, this could be someone who is a foster child. So a child and a ward are both considered minor since they both would be considered under the age of majority. Then to the right side of the slide, we have two other terms. We have emancipated minor and we have mature minor. With emancipated minor, this is a person who is recognized to have the full legal rights of an adult under local law, even though he or she is a minor. So a minor person who has not reached that age of majority can be considered essentially an adult and consent for themselves if they're, for example, married, or if they're enlisted in the military, or if they're living independently. Typically, they file this request for emancipation through the court, and the court will decide whether or not to grant that emancipation. So here, when I'm talking about emancipated minor, I'm actually talking about a person who would be consenting for themselves to be in research, not providing assent. Mature minor. This is a person who, under local law, may consent to certain health care treatment or procedures even though they are a minor. So an example of this, let's say you have a 15-year-old who's sexually active, and they have contract a STD. They may be able to consent for themselves to receive treatment for the STD even though they are not that age of majority. They are not an adult yet. So here, if we're talking about a mature minor in research, again, like emancipated minor, it may be that instance where they could consent for themselves because they'd be considered a mature minor, as opposed to just have to assent with having their parent also provide that consent. So keep in mind, emancipated minor, mature minor, when we're thinking about that, understand those terms in your local jurisdiction, and they may not actually have to provide assent. They can consent for themselves. But minor, child, and ward would have to provide assent. Let's try to conceptualize this. So again, we have minor. This is the overarching term because each of the 4 people on the outside of this chart here would be considered a minor because they're under the age of majority in their local jurisdiction. But at the top, a mature minor and an emancipated minor may provide consent to be in the research, so they can consent for themselves. But down below, if you have a child or a ward who are also a minor, they must provide assent. So parents or guardians will consent on their behalf, and the child or ward will provide assent. Now, when I talk about a minor in the age of majority, again, this depends on the local jurisdiction, or typically the state in which you're conducting research. So here's a map of the United States. The age of majority in most states is 18 years old. There are some exceptions. For example, you have Pennsylvania that's 21. This is actually a really confusing state. So in Pennsylvania, the age of majority is presumed to be 21 unless a regulation or law states otherwise. Well, if you actually dig into the regulations and laws of Pennsylvania, what it does say is that a person reaches the age of medical consent at 18 or upon graduating from high school, being or having been pregnant or getting married. So while the presumed age of majority is 21, someone who's 18, just by considering the regulations, may actually be able to consent for themselves to be in medical research. So again, understand the age of majority in the local jurisdiction in which you reside. Again, typically that's the state in which your research is taking place. Also in Canada, you can see the gray provinces there. The age of majority is 18, and the other provinces and territories are 19. Also understand that age of majority where you're conducting research. For example, in British Columbia, the age of majority is 19. But someone under 19, not necessarily even 18, could be even someone younger, could potentially consent to medical research if 2 things happen. 1, the healthcare provider is satisfied that the minor understands the explained nature and consequences and the reasonably foreseeable benefits and risks of the medical care. And 2, if the healthcare provider made reasonable efforts to determine and concludes that the medical care is in the minor's best interest. So let's say that's an oncology trial and you have a 17-year-old. Does that mean the child can consent for themselves? Yes, it's possible. Now, the definition of assent is a child's affirmative agreement to participate in research. The federal regulations even specifically point out that mere failure to object may not be construed as consent. So how do you determine how to administer assent and whether or not assent signature should be provided or whether or not oral assent should be provided? And you simply document that in the participant's chart. The regulations tell us the IRB should consider 3 things, and so researchers out there, you should consider 3 things. The age, the maturity, and the psychological state of that pediatric population that you will be enrolling into your research. Let's take those 3 things and let's play those out in actual practice. So in practice, we're typically talking about when we're having consenting pediatric population, we're talking about consent and assent. I've already covered that consent where a parent or guardian will be consenting on a consent form on behalf of the child. In terms of assent, I've broken this down into various ages. So if a child is below the age of 7, again, it's presumed that all children should have to provide their assent, but here, if a child is below age 7, it's actually typically presumed, and this is presumed, not just simply a standard made up, but it's one put forth by the National Commission, the same commission that came out with the Belmont Report, that pivotal document of human subject protection. And it basically says that maybe you don't actually have to get assent if someone's below 7 because the capability of some or all of the children is so limited that they cannot reasonably be consulted. Or 2, the study presents the prospect of direct benefit that is important to the health or well-being of the children and is available only in the context of research. So when we're talking about enrolling a population that's below age 7, the requirement for assent may be waived if one of those 2 instances are present. What if you have ages between 7 and 18? So here we have options for this age group. The first option, you can actually have an assent form, one assent form separate from the consent form for ages 7 to 18, and you should make sure the reading levels in that document are at the level at the lowest age. Here, a participant would sign the assent form, or if the IRB finds this is appropriate, have oral assent and document this in the participant's chart. So that's one option. You just have one assent form for 7 to 18-year-olds, and again, you'd have a separate consent form for the parent or guardian. Option 2, you can break it down further. You can have that separate consent form for the parent and guardian, and then you have an assent form for ages 7 to 11 and ages 12 to 18 with reading levels at the lowest age. So here you're presuming that the reading comprehension of 12 to 18-year-olds is significantly different than those who are 7 to 11, which very well may be the case. In that way, you can have two assent forms. The participants who are 7 to 11 would assent on that form. Participants who are 12 to 18 would assent on that form. And again, parents would consent for the participation of their child on the consent form. Option number 3 for ages 7 to 18. You can have that assent form now that's 7 to 15, or you can have assent form 7 to 11 and 12 to 15, but here's the new twist. You can have a consent and assent form for participants who are 16 to 18. So basically, if you're below 16 years old, you're going to have an assent form, which if you're a child, you will provide your assent signature. But let's say you turn 16 to 18, and again, I picked the age 18. I think we all understand now there may be a local jurisdiction where that age is different, but I've just picked 18. That's the most standard. So if you are a participant who's 16 to 18, you will actually be providing your assent on the consent form itself. So in that case, there's going to be a consent form that's going to be written at the reading level of the lowest age, so 16, and the parent or guardian is going to sign their consent on that consent document, and right below that signature line of the parent or guardian is going to be the assent signature line, and the child is going to assent right there. So they're going to assent on that actual consent form. That's why we call it a consent/assent form. One thing to point out for all these ages, again, make sure you understand the age of majority. I used 18 because that's the most common one. And also know that whenever a participant who's providing their assent turns the age of majority, so 18 or 21 perhaps, that participant must actually then be consented on the consent form. That's important to note. So we talked about you can waive the requirement for assent if children are below the age of 7, and then there's also ways to handle actually obtaining that assent. Note that the IRB could, in fact, waive the requirement for assent altogether, no matter what the age or maturity or psychological state, and it could do this if the study is not under the FDA's jurisdiction. So the IRB may waive assent altogether if the following 4 criteria are satisfied. The clinical investigation involves no more than a minimal risk to subjects. The waiver will not adversely affect the rights and welfare of the subjects. The clinical investigation cannot practically be carried out without the waiver. And whenever appropriate, the subjects will be provided with additional pertinent information after participation. If these elements look familiar, they are the exact same elements that are for waiver of consent under the Department of Health and Human Services regulations. Let's test our knowledge on assent. An IRB reviewing a non-Hodgkin's lymphoma oncology clinical trial with the potential for direct benefit waived the requirement for assent for those participants under the age of 7. A 6-year-old child with non-Hodgkin's lymphoma is enrolled in the trial. After 3 months in the trial, the child has her 7th birthday. Must the child be provided with the assent form for participants 7 to 11 years old and provide her assent in order to remain in the trial? We'll give you a moment to provide your answer. Okay, the answers are in. It looks like the majority said yes. I think this is actually a very gray area, so I'm sure there's lots of support for why people would say yes. My answer is actually going to be no, and here's the reason. The regulations don't, we know when you turn 18 you have to provide consent. It's actually not clear when you move up a different assent age range whether or not you have to provide your assent. Of course, we always want to respect the participant's wishes, so the child's wishes. So it would be very important, I think, to make sure to assent this child. But because nothing specifically requires it, and for the other following reason, I said no. And that other following reason is this. Here, the trial is likely to present the prospect of direct benefit and is likely only available in the context of research. Therefore, assent may still not be required for the child because it's in the child's best interest to remain in the study. So there's reasons for saying yes, and I think reasons for saying no here. It's what's the most key thing is to consider that specific participant's situation when you're determining whether or not to have that child provide their assent to continue in the study. Again, we always want to respect the wishes and make sure we have that assent, but there may be other factors. For example, is the research like an oncology trial where the medication is only available in that trial? It's important to make sure to remain that child in the research. Now our final section today, conducting research in pediatric populations. Here's where we actually talked about if you're conducting the research itself, what are some things you should consider? So in order to approve pediatric research that is permitted under the regulations, under one of those 4 categories, an IRB must ensure the following things. Risks to participants are minimized, risk to benefit ratio is acceptable, selection of participants is equitable, informed consent and assent will be sought and documented, there are adequate safety monitoring in place, adequate privacy protections are in place, and there are additional safeguards in order to protect the rights and welfare of participants. This is the same criteria we would consider, and the IRB would consider if you're determining whether or not to approve research in adults, but we're applying that to children. Because we're applying that to children, I want to focus on 2 of those bullets specifically. 1, what does it mean to actually minimize risk to participants? And 2, what are those additional safeguards that you can put in place when you're enrolling children in research? Let's first start off by talking about how to minimize risk to participants, to these pediatric participants. So what I find helpful to consider what you should actually do to help minimize risk to children participating in research, I like to consider risks from the perspective of a child. So if you're a child enrolling in research, you may think medical facilities are scary and cause distress. So to address this issue, conduct research in a child-friendly atmosphere to reduce distress. I think if anyone's been to a children's hospital as opposed to a hospital that only serves adults, you're going to notice a distinct difference. The children's hospital has brighter colors, seems more friendly, seems to put people's minds more at ease. So consider that if you're conducting research in children. If you're not at a children's hospital, consider having play equipment, furniture appropriate for children, age-appropriate food, or activities. Another risk that a child may think of is medical procedures hurt. Because they hurt, use procedures to reduce pain. Example, use topical anesthesia to place IV catheters, or use indwelling catheters rather than repeated venipunctures for blood sampling. So think about that. Think about how to reduce pain to children. A child may also think more procedures equal more distress and more pain. Therefore, be efficient to reduce distress and pain in children. For example, if possible, conduct interventions at the same time clinically indicated interventions are scheduled. Make sure to utilize staff that is experienced working with children to ensure they are skilled and quick at administering procedures. You don't want to have a phlebotomist or a nurse or someone who's unfamiliar working with children who has to prick the child to get the needle in or to obtain enough blood over and over again. That's going to be very distressing to the child, so make sure you have people that are trained to work with children. That's considering risk from the child's perspective. Also consider risks from the perspective if you're a sponsor or a researcher. So consider how to minimize risk to children by tailoring the consent process to children. Design the consent and assent process to ensure comprehension, appropriate parental guardian involvement, and privacy issues. So for example, Use assent forms that are written at the appropriate reading level. In the assent discussion, use graphs, charts, and visuals to ensure there's going to be comprehension from the child. Also, if necessary, separate out discussions with the children and the parent. Sometimes there's going to be very uncomfortable discussions regarding medical issues where it would be nice to have the parents hear about it and the child hear about it separately. Next, from a researcher perspective, minimize risk to children by scientifically evaluating risks. So, for example, design protocols to protect against adverse event outcomes that generally only affect minors. That means if there's a way, ensure that impairments in cognitive growth or skeletal development will not occur. Another example, reduce the overall amount of blood required for the study by using sensitive assays, pediatric-enabled laboratories, and population pharmacokinetic approaches. We know these different approaches in these laboratories may be more expensive than your standard laboratory, but you will need less blood to obtain the same result, and that may be worthwhile when you're conducting research in children. So I mentioned blood volume. This is actually a very hot topic. It's a question we get a lot at Quorum, so I want to digress just for a moment and talk about blood volumes. So blood draw volumes in children, people often want to know, how does the IRB actually determine what the appropriate blood draw volume is? Well, the IRB determines this by taking into account the following factors: the type of research in which the child is enrolled, severity of the child's condition, hemoglobin levels, frequency of blood draws, collection procedure, age of population, and if there's a protocol justification for the amount of blood volume being drawn. So that's what the IRB considers. I know when people think about blood volume, though, they want something more concrete, give me numbers. So the IRB can also rely on outside documents. For example, Seattle Children's Hospital has a blood volume chart. This chart also has the same volumes that are used by other children's hospitals and institutions around the country. And what this document says is that it actually provides a maximum allowable blood draw volumes. This would include clinical blood draw volumes and research blood draw volumes. And it says a maximum of 2.5% of total blood volume in one blood draw and a maximum of 5% of total blood volume in a 30-day period. So there's some concrete numbers just to consider. Of course, there's going to be a lot of factors to factor in there when the IRB is going to make its decision. Let's test our knowledge in this area. A study in children involves several blood draws over the course of 30 days. The target total amount of blood drawn within that time is 5% of a participant's blood volume. The protocol for the study notes that a blood draw may have to be repeated in the event that a child's blood sample is contaminated in the laboratory. Is the potential blood collection volume acceptable? I'll give you just a few moments to provide your answer. So it looks like the majority of people said no, and I would agree. So in this scenario, it looks like we are actually within that allowable maximum blood volume, although we're pushing right up to that maximum. The issue to consider here is that there may actually have to be another blood draw. If there were another blood draw because blood got contaminated in the laboratory, that would push the volume amount over that allowable level. This is something we see at Quorum a lot. You may have various blood draws considered, but there may be issues written into the protocol where if something happens, a blood draw may have to be done again. So consider all blood draws that may occur when you're determining what the maximum blood volume amount may be. So we talked about minimizing risks when having children in research. What are additional safeguards that can be put in place when you're having children research? This is also a very confusing area and one that we get a lot of questions, because what does it actually mean to have additional safeguards in place when there's a vulnerable population in the research like children? Well, the first thing to note is that one additional safeguard is the fact that research in children can only be approved if it falls into one of those 4 categories we talked about today. Now, second, there are other safeguards to know about. For example, you could, the IRB, or as the research side or as the sponsor of CRO, you could require that each investigator has the appropriate training and expertise in pediatric populations. So this means using a pediatrician, or if it's an oncology study, use a pediatric oncologist, for example. So that might be a safeguard you could put in place. Have more frequent DSMB meetings. Make sure there's these frequent meetings to scour over the adverse events that are occurring, to pinpoint any issues that may have to be fixed or any protocol amendments that may have to come before children get hurt. In terms of assent and consent, omit any discussion of compensation from the assent discussion. This could be additional safeguard because you're making sure children are not being unduly enticed to be in the research. Also, you could develop documents to periodically check a child's willingness to continue in the research. Remember, assent is an active and ongoing process, so it could be appropriate to check in and to always check in with the child at set times to make sure they still want to be in the research, and there can be documents that you can make for this type of check-in. So these are just some examples of additional safeguards you can put in place that hopefully gets your mind thinking that, oh, that's what it means when we're talking about additional safeguards when we're enrolling a vulnerable population, such as children. So the key takeaways from today. First, from the beginning, we know that research in children is important, and we also know that it's important to understand how to protect the right safety and welfare of these young participants. The key regulatory documents we're talking about submitting pediatric research to the IRB are 21 CFR 50, Subpart D, 45 CFR 46, Subpart D, and in Canada, ICH E11. Next, the IRB can only approve research in children that falls into one of 4 categories, and these categories also tell us whether the consent of one or both parents' guardians is required. Next, tailor your advertisements appropriately to children when they are your audience. Permission and assent are required in order to enroll children into research, and understand how to obtain and document both. Finally, always ensure that research minimizes risk to children and includes additional safeguards. So with that, I'm going to pass the remainder of the presentation back over to Ari for some concluding remarks.
Thank you, Mitchell, for this informative webinar. I'd like to let our viewers know that if you have any additional questions, there will be an opportunity to submit questions via our survey at the end of this webinar. Alternatively, you may submit questions to clientrelations@quorumreview.com. We'll do our best to follow up individually or answer your questions in the Q&A that we'll post on the website. And another reminder about the webinar recording, the slide deck, and Q&A, they'll all be posted to our website. We'll email you a link to view these items as soon as they're available. And I'm going to give one more plug for our survey. So we do really value your opinion, and once this webinar concludes, you'll get a browser pop-up where there will be a survey. Do please take a few moments to fill the survey out and give us your feedback. We use the information to develop future content. And once again, I want to thank you for attending our webinar. We hope you found the topic informative and useful. If you're interested in learning more about Quorum, visit us at quorumreview.com. You can also find us on the following social media outlets. We're on Facebook, Twitter, LinkedIn, and YouTube. And on behalf of everyone here at Quorum,